In Chapter 4, we will begin our discussions about the legalities related to managing employees with the topics of employment and staffing. Once completed with this module, you should be able to analyze the issues associated with recruiting and retaining EMS personnel and identify best practices in each area. Describe the importance of background checks and be familiar with the rules and regulations governing employer and employee rights during background checks. Identify the applicability of the Immigration and Naturalization Act, the Rehabilitation Act of 1973, and the Fair Credit Reporting Act, and analyze the ways in which each state governs hiring practices. Develop a basic understanding of the Civil Rights Act of 1964 and relate its provisions to the hiring of EMTs. Describe why affirmative action consent decrees were issued in the 1970s. Identify best practices in maintaining EMS personnel to avoid EEOC complaints concerning racial or religious discrimination, and identify the critical incident stress management services available to EMS and describe the importance of confidentiality for those who receive such services. To begin this discussion on EMS agency employment and staffing, what would you do if you were the recruiting officer for your service and a potential applicant only has 3 fingers on one of his or her hands? Do you ask the candidate to undergo a physical abilities evaluation? How about having the candidate see a physician? Is the testing process non-discriminatory? By the end of this module, you should have a better idea of how this and other related personnel matters should be handled. It goes without saying that one of the most important functions of an EMS or other public safety organization is hiring good quality employees. Not only will these employees have a direct impact on customer care, they can also impact your organization in both positive and negative ways. Having a good recruiting program in place is important, as is the need to ensure all of the steps within the hiring process are followed. Unique factors, such as an agency's call volume, geographic area, and other factors, will determine the number of employees needed and at what level of licensure. Ultimately, a comprehensive hiring process helps EMS employers select the best possible employee from a group of well-qualified applicants. The recruiting and hiring process is very important, and it is also very complex with many opportunities for error. To minimize potential legal liability, in addition to simply trying to hire the right person for the job, it is in the best interests of every EMS agency to take the time to develop and maintain recruiting and hiring practices that meet standard criteria under applicable state and federal laws. A failure to ensure compliance with employment laws is a surefire way for an organization to find itself in court, as aggrieved employees and even candidates who were never hired may find themselves with a valid claim against such an employer. To begin, there are many ways to recruit candidates. While the use of online avenues such as social media and employment websites is commonplace, attending job fairs, placing ads in newspapers and trade magazines, job postings at local schools or colleges, internship opportunities, or even word of mouth are all valid ways to recruit talented people as well. Before recruiting can begin, however, the employer needs to know what type of employee is needed. What is the employer looking for? To aid in the recruitment process, the employer should begin by drafting or verifying a job description for the position that denotes the essential functions of the job, work hours, physical requirements, required licenses and/or certifications, minimum age if appropriate, educational requirements, and necessary experience. To avoid potential legal problems, especially within the areas of protective service and public employment, recruitment efforts should strive to find individuals reflective of the community served. In addition to ensuring the candidates have the cognitive knowledge and skill set necessary to function as EMS providers, the EMS service manager must also assess intangible traits, such as the candidate's character, values, ethics, and likelihood of dependability. To address these aspects, the application should ensure the candidate is aware that a background check will be performed before an offer to hire can be made. If there is also a probationary period after hire, this should be shared as well. The application and testing process should include several components, such as a background check, which is more than just having the local law enforcement agency run a driver's license abstract, verification of legal status to work, social media behavior, unless such checks are prohibited by law, a potential written examination, a physical or physical ability test, and possibly oral examinations. This may sound like a lot, especially if the EMS agency is a volunteer service that has difficulty finding members. All it takes is one bad hiring decision, however, and a failure to perform due diligence in hiring an EMT can result in time-consuming and expensive legal problems for the EMS agency. As just mentioned, a background check does not mean just checking an individual's driving record. Rather, the employer should check state and federal criminal records, conduct interviews with former employers, and even perform a home visit. If the potential employee lived out of state for any period of time, it may be necessary to check criminal background records from other states as well. On the employment application itself, the EMS agency should have language indicating such checks will be completed and that the applicant provides his or her permission for them to be conducted using the information provided on the application. Once a full background check is performed and the candidate is deemed acceptable, a comprehensive physical examination should be conducted by a physician. This physical accomplishes a couple of things. The first is that it ensures the candidate is healthy enough to be an EMS provider in the field by validating the candidate can perform the essential functions of the job, either with or without reasonable accommodations. The second is that if the candidate is eventually hired, the examination established a baseline for future medical evaluations that may be conducted at some point in the future. This can tie into workplace safety and health initiatives, as well as workers' compensation and duty disability claims. The candidate will need to provide his or her Social Security number to the employer for numerous purposes. Social Security numbers are often used to uniquely identify individuals in criminal background and other checks, for the purposes of obtaining court records, to validate prior military service, to verify citizenship or immigration status, and to report wages and earnings to taxing entities such as the state and federal governments. Given concerns about identity theft, Social Security numbers are considered to be sensitive, personal information, and the employer has a legal obligation to protect an employee's Social Security number from disclosure to parties who do not have a legitimate reason to have it. As technology continues to evolve, so too must our laws regarding the use of that technology. The use of social media has become one of those areas where perceived employer abuses have resulted in the creation of laws to protect current and potential employees from unfair practices. The scenario is a relatively simple one. The employer asks the candidate during an interview for his or her Facebook password, asks the candidate to friend the employer on Facebook, or may even have a computer terminal right there and insist that the candidate log into his or her social networking accounts so the content can be scrutinized by the employer. Many consider this to be a violation of privacy, and if the employer is a government agency, such tactics through the guise of being part of an employment action can be worrisome. To combat such violations of privacy, some states passed laws prohibiting such practices. The textbook author makes reference to the Password Protection Act of 2012, but that law was not passed by Congress and has been reintroduced several times, including Bill H.R. 2227 on May 12th of 2015. Whether it will make it through the legislative process to become law is anyone's guess at the time this presentation was produced. Within Wisconsin, the state does indeed have a law that deals with this topic. Signed by the governor in April 2014, the Wisconsin Social Media Protection Act prohibits employers from requesting or requiring an employee or applicant as a condition of employment to disclose access information such as passwords or usernames to personal social media accounts or to otherwise grant access to or allow observation of the account. As codified in Statute 995.55 sub 2, an employer cannot terminate or otherwise discriminate against employees because he or she refuses to provide the employer access to a personal social media account, and the employee cannot be the victim of adverse action for exercising that right. It is important to note, however, that employers still have the right to require access to electronic devices, services, or accounts provided, supplied by, or paid for by the employer. Employees may be disciplined or discharged for transferring an employer's confidential or financial information to a personal social media account, and, given reasonable cause to believe that something like that occurred, the employer may require the employee to grant access to or allow observation of the employee's personal account, so long as the employee does not have to disclose the access information for the account. The employer may restrict internet site access on its own devices or network. The law also permits the employer to comply with a duty to screen applicants for hire as required by state or federal laws, rules, or regulations. This means that the employer may still examine the candidate's publicly viewable social networking information. A violation of this law subjects the employer to a $1,000 forfeiture and, more importantly, it creates a basis for a claim against the employer under the Wisconsin Fair Employment Act. Depending on how competitive the hiring process is in relationship to the number of applicants for jobs, it is not unusual for employers to rate and rank candidates based upon performance on a written test. Such tests commonly gauge the candidate's reading, writing, math, and information processing skills. While some examinations are graded as simply pass-fail, others are utilized to place candidates in rank order. The challenge with written tests that every employer must be aware of is the fear of discrimination against a select group of individuals. Such discrimination is typically not intentional on the part of the employer, but it occurs nonetheless. Referred to as disparate impact, this is discrimination that is not intentional, but still results because of bias introduced within the testing instrument itself. For this reason, many employers who utilize a written examination in this fashion will purchase a test from a vendor or third party that has been validated and potentially tested in court to ensure no disparate impact results from the administration of the test. In addition to ensuring the employment candidate has the cognitive skills to function as an EMS provider, the job itself is also physically demanding, and the employer must ensure the candidate can perform the essential functions of the job. In addition to a medical screening by a physician, it is not unusual for employers to require a physical ability test to evaluate the employee's strength, endurance, and other skills as they are related to the job. For such tests to be valid, they must commonly meet two thresholds. First, they must be job-specific. This means that the physical examination must actually test the candidate on job skills that the candidate will be performing. In the case of EMS, this would include essential job functions such as carrying, lifting, climbing, squatting, and other related physical tasks. The old days of requiring candidates to perform sit-ups, push-ups, pull-ups, or run a mile in a given time frame are no longer valid, as those tasks are not performed as a part of the routine functions of the job. True, one may argue that those type of general physical conditioning activities relate to the overall physical fitness of the candidate, but the relationship between those general physical fitness tasks and the actual essential job functions associated with being an EMS provider is much too nebulous for the courts. Additionally, the physical ability test must be verifiable. This means that current employees who are performing the same job can complete the same tasks within the same constraints as the candidates being tested. For instance, if the physical test requires a candidate to lift 100 pounds, yet none of the service's current EMS providers can pass that station themselves, that is a problem that impacts the verifiability of the test. An example of a physical ability test that is job-specific, verifiable, and recognized as such by courts is the Candidate Physical Ability Test, or CPAT, that was created by a joint initiative between the International Association of Firefighters and the International Association of Fire Chiefs. This test requires firefighting candidates to demonstrate the ability to perform tasks they would be asked to perform on the fire ground, such as climbing stairs while carrying additional weight, swinging a sledgehammer, using a pike pole, navigating a dark space, and pulling hose. Before using the CPAT, the testing agency needs to verify the weight associated with various tools it uses to ensure the same weight tools are used in the test. Additionally, the agency must determine an acceptable time through a statistical analysis of times to complete the course by their current employees. While this type of physical ability test is somewhat common for fire departments, it is not as prevalent with EMS agencies, especially private providers that are not fire-based. Another caveat with the CPAT is that it was actually designed as part of a larger health and wellness initiative to encourage ongoing physical fitness activities. Before the CPAT is administered, the candidates must have the opportunity to try the stations, and the testing department is supposed to provide the candidates with other opportunities to practice the various stations within the test. While the duties of a firefighter are somewhat different from those as an EMS provider, it is easy to see how a similar type of physical ability test could be employed by an EMS agency by requiring candidates to lift patients or mannequins to simulate patients, move patients down steps, transfer cots into an ambulance, and so on. Ultimately, each community needs to determine its own needs and develop a testing process based upon those needs. Regardless of what type of physical ability testing is performed, the candidates should have an opportunity to practice the testing components or skills prior to being evaluated. Any testing bias must be eliminated, which means the agency must ensure the testing stations are directly related to or simulate the required job tasks performed by its personnel. To go a step further, non-essential components in a physical ability test could give rise to a valid legal challenge. The testing of job-specific skills or essential functions of the job can be necessary to ensure the candidate can function as an EMS provider once hired. To avoid legal complications down the road, however, the employer may want to consult with an attorney familiar with this area of employment law to ensure the proposed test or the test currently in use complies with recognized legal requirements. Once candidates complete the written and physical testing process, it is uncommon for the top-ranked individuals to participate in oral interviews, typically in front of a board of interviewers. When such interviews are conducted, it is typically recommended that the questions asked of the candidates be scripted, and those conducting the interview not deviate from the scripted questions. The reason is to avoid claims that the process was not standardized and different candidates were asked different questions with varying levels of difficulty that may have been predicated upon an illegal basis on the part of the interviewers. Sticking with the script, assuming the questions are approved by legal counsel, also helps ensure the candidates are not asked illegal questions during the interview, such as those related to the applicant's age or date of birth, religious affiliations, sexual orientation, national origin, medical history, or disabilities. So long as a question is non-discriminatory or does not create a bias for or against the applicant, it can be asked of the candidate. What constitutes a discriminatory or bias-inducing question, however, can be a matter of opinion, and interview questions should be carefully crafted by an attorney or a human resources professional. Again, all candidates must be asked the same questions, and an objective assessment sheet should be used by the interviewers to gauge the performance of the candidates. While many employers may not have bad motives when asking prohibitive questions of a candidate, the subjective intent of the employer is largely irrelevant if the candidate feels he or she was the target of illegal discrimination based upon the questions that were asked. Therefore, it is important for the EMS manager to know what questions are appropriate to ask and, inversely, which ones are inappropriate. While not necessarily related to legalities surrounding the hiring process, it is simply good practice for a hiring manager to consider the desired type of employee based upon the agency's mission, vision, and core values. Honesty, integrity, trust, and the ability to preserve the agency's reputation and the quality of patient care are all vital characteristics for a new EMS provider within any EMS agency. Employers should strive to provide equal opportunities to all who apply for positions within their organization, but they should also consider the demographics of the area they serve and ensure their recruitment activities strive to develop a candidate pool that is representative of those demographics. This need will be more apparent when discrimination, affirmative action, and consent decrees are discussed later in this chapter. Discrimination in employment can lead to considerable legal liability for an employer unless the employer can show a specific reason based on business necessity as to why the discrimination is necessary. Such exclusionary requirements in employment are referred to as bona fide occupational qualifications. Examples of bona fide occupational qualifications include instances where a theme park can only hire people of specific heights and weights to wear character costumes within the park, a theater production looking for an actor of a particular gender to play an important character, or a religious-based grade school that will only hire individuals who share the same religious beliefs. In these specific instances, bona fide occupational qualifications based upon height, weight, gender, religion, or something else may be considered in the employment process. Such qualifications must be listed in the employment offering, and the employer must ensure it has carefully considered whether or not the bona fide occupational qualifications are indeed reasonably necessary to achieve the organization's goals. Wisconsin Statute 111.321 defines protected classifications of individuals within the state. Discrimination in employment based upon any of these classifications is illegal unless very strict exceptions or special cases apply. This list includes age, race, creed, color, disability, marital status, sex, which denotes gender but also includes orientation, national origin, ancestry, arrest record, unless the conviction is considered substantially related to the position, military service, the use or non-use of lawful products off the employer's premises during non-working hours, and declining to attend a meeting or participate in any communication about religious or political matters. While national origin is recognized as a protected class in Wisconsin, all workers, regardless of where they are from, must be legal to work within the United States. This requires employers to verify the candidate's eligibility to legally work in the United States as required on a Department of Homeland Security, U.S. Citizenship and Immigration Services I-9 form. The form requires both citizen and non-citizen employee candidates to present documentation to the employer that establishes both positive identification as well as employment eligibility. The forms of identification considered acceptable for these purposes include passports, driver's licenses, social security cards, birth certificates, and other vital records. Some documents must be provided in tandem, such as a state-issued driver's license to establish identity and a social security card to verify legal status to work. A passport, on the other hand, can be utilized to establish both identity and legal status to work. After going through the testing, interview, background, and other processes as previously defined, the time will come to make the most qualified candidate or candidates a conditional offer of employment. More than likely, there will still be some additional testing required of the candidate before the individual's employment can actually begin, and the conditional offer of employment should outline these requirements. Such additional testing may include additional background checks, credit checks, psychological testing, medical screening, and possibly a final oral interview with the Chief Operating Officer of the organization. The textbook author briefly mentions the legality of using a polygraph, voice stress analyzer, or other type of lie detector or honesty detecting device within the employment process. While the law varies considerably from state to state, the practice is prohibited in Wisconsin unless very specific exceptions apply. Generally speaking, especially for the purposes of an EMS agency hiring a new employee, the use of an honesty testing device is prohibited in Wisconsin under Statute 111.37. Some employers also pull the credit history of the applicant to gauge his or her trustworthiness. If an employer decides to check a credit report when hiring potential employees, the employer must comply with the requirements of the Federal Fair Credit Reporting Act. This act requires employers to obtain consent from the candidate before pulling the report, give a warning to the candidate along with a copy of the report received if the employer plans on rejecting the candidate based upon the contents of the report, and provide an official adverse act notice if the employer actually does not hire the candidate based upon the information contained within the credit report. Depending on the organization, it is also not uncommon for employers to visit the candidate's former workplace and the candidate's place of residence. As far as employment references are concerned, the state of Wisconsin has a law, State Statute 895.487 sub 2, that provides civil immunity for an employer who gives an employment reference in good faith. Good faith is presumed in these cases, so it would be incumbent upon the plaintiff in a subsequent lawsuit to show by clear and convincing evidence that an employer knowingly provided false information in the reference, that the employer made the reference maliciously, or that the employer made the reference in violation of Wisconsin's anti-discrimination law, State Statute 111.322. If the former employer has an agreement with the former employee about such references, the agreement must be honored. Otherwise, the reference may relate to any aspect of the former employee's job performance or qualifications for employment. Some states do not have this legislation, and it is not uncommon for employers to provide nothing more than confirmation that a person worked there previously. If a good reference is provided for a bad employee, there is a concern that the former provided a false or negligent reference. Inversely, if a bad reference is provided for a good employee, the former employee may start a defamation claim against the former employer. While this chapter deals with hiring employees, it is important to keep in mind that, as an EMS employer, you may be asked to provide a job reference for a former employee. The best advice is to be familiar with the laws of your state and to ensure any reference is provided in good faith based upon facts and evidence. Personal opinion should be avoided. Lastly, the organization should have a final list of candidates for hire in rank order based upon non-discriminatory criteria. When talking about protected employment classifications, there are federal requirements defined in the Civil Rights Act of 1964 that prohibit discrimination based on race, color, religion, sex, which is gender, and national origin. The application of this law also requires employers to reasonably accommodate an employee's sincerely held religious practices. Title VII of the Civil Rights Act created the Equal Employment Opportunity Commission to implement and enforce a law protecting the rights of individuals to be free from unlawful discrimination based upon protected classes. Subsequent laws also added protected classifications, such as age and pregnancy. The Age Discrimination in Employment Act prohibits age discrimination against individuals 40 years of age or older, and the Pregnancy Discrimination Act makes it illegal to discriminate against someone on the basis of pregnancy, childbirth, or a related medical condition. The Equal Pay Act of 1963 prohibits discrimination on the basis of gender and compensation for substantially similar work under similar conditions. Section 501 of the Rehabilitation Act of 1973 prohibits employment discrimination against federal employees with disabilities. A few decades later, Congress passed the Americans with Disabilities Act, which prohibits employment discrimination against the disabled by virtually all employers, both public and private. Going back to 1965, there was an executive order that required government employers to take affirmative action to hire individuals in underrepresented groups in areas of employment, education, and business, giving preferential treatment in hiring, college admissions, and awarding of government contracts. Today, such practices are becoming less common as reverse discrimination lawsuits are succeeding in the courts. While Wisconsin was already discussed, other states commonly have their own laws about discrimination in the workplace. As an example, California passed Proposition 209 in 1996 to prohibit government employers from discriminating against or giving preferential treatment to individuals or groups on the basis of race, sex, gender, color, ethnicity, or national origin. Many of these laws, such as the ADA and the ADEA, specifically prohibit the use of discriminatory employment tests and selection procedures. Title VII also prohibits what is known as disparate impact, where there may not be an intent to discriminate in the employment process, yet the results of the process are still statistically discriminatory. The use of written examinations, for instance, can be very discriminatory, especially against individuals from lower socioeconomic backgrounds, which can correlate to specific races or ethnic groups. This is not always the case, but such examinations must be very carefully researched, crafted, and validated to ensure they do not result in a discriminatory, disparate impact. Such examinations should also be related to the candidate's ability to perform a job. Otherwise, the examination may very well eliminate the best qualified candidates from the employment process. As just mentioned, it was not uncommon in years past for hiring processes to select one category of employee over another by use of a particular type of test that ultimately resulted in a bias against a specific race. To combat this practice, courts started issuing consent decrees in the 1970s to guide the hiring process for public employers. These consent decrees typically required the employers to hire individuals from specific race or ethnic categories on a percentage basis. Currently, however, there is some debate as to whether there is still a need for consent decrees. The good news is that civil rights initiatives such as consent decrees from the 1970s appear to have finally achieved their intended purpose. As a result, many fire departments hiring under such decrees are appealing those rulings and are successfully having them removed. To maintain a consent decree in the light of a potential reverse discrimination lawsuit, the hiring entity must show a compelling governmental interest in the continued use of a consent decree by providing substantial evidence that there are continuing and present effects of past discrimination against minorities. Given the timeframes involved, however, one would have to wonder what such an employer has been doing all these years if the hiring process still results in disparate impact against minorities, which could potentially result in additional litigation from those negatively impacted by the discriminatory process. Ultimately, employers must have a hiring process in place that provides equal opportunity to everyone qualified to pursue the position. Intentional discrimination is illegal, as is discrimination that occurs through disparate impact, typically through a flawed hiring process that often fails to properly recruit qualified candidates from diverse backgrounds. Shifting gears from hiring, we will now look at staffing requirements for ambulances, as those requirements will play a significant role in an EMS agency's need to hire and maintain personnel. Required ambulance staffing is typically determined by the laws in each individual state. BLS ambulances, for instance, are commonly required to be staffed with a minimum of 2 EMTs. Advanced life support ambulances will routinely require at least 1 paramedic along with an EMT or advanced EMT. Due to the cost associated with training and maintaining paramedics, some areas utilize the advanced EMT level to provide some advanced skills where paramedics may not be available or feasible, especially in rural or remote areas. Although one could argue these are the areas that benefit the most from paramedic level services, as they are also associated with longer transport times to hospitals and other definitive care facilities. Ultimately, it is often up to an individual community to determine what level of risk they are willing to tolerate, which then defines how many BLS and ALS personnel must be hired and maintained. Some communities, for instance, are satisfied with BLS care, while others want multiple paramedic units available. Staffing models should consider state law, local mandates or policies, community need, community demand, response times, call volume, and revenue available to adequately fund the EMS system. In some areas, there may even be a difference in requirements between public and private EMS services if the staffing matrix is dependent on area contracts and budgets. The book author goes on to state that private ambulances are required to comply with state staffing requirements as guided by state law or the appropriate authority having jurisdiction over such matters. As we will see shortly, such laws and requirements commonly impact public providers of EMS as well. There are several nationwide organizations that provide ambulance staffing recommendations, such as the National Fire Protection Agency, Commission on Accreditation of Ambulance Services, and the American College of Emergency Physicians. As we are about to see, however, Wisconsin has some specific requirements for ambulance staffing within the state, rendering the opinions of these other organizations somewhat irrelevant. Within Wisconsin, State Statute 256.15 sub 4 defines the staffing requirements for ambulances. In general, an ambulance must be staffed with 2 licensed EMTs or higher. Administrative Rule DHS 110.50 sub 1 provides additional clarification to this statute. For instance, paramedic services licensed before January 1, 2000 must have 2 paramedics on an ambulance, while paramedic services licensed on or after that date may function with a single paramedic and 1 other licensed EMT at any level. The caveat to this information is that, at the time this presentation was prepared, the governor had recently signed Act 113 to reduce staffing requirements in smaller municipalities to include an EMT and an EMR, as opposed to 2 EMTs. If you are a manager or leader of an EMS agency serving a population of less than 20,000, the updated language in 256.15 sub 4, given the passage of this law, may be of interest to you. Once you hire an employee, it is important to then retain that person as a productive employee. Retention of a new employee is a long-term process to ensure the employee remains a productive and competent member of the organization. From the employer perspective, maintaining a good relationship with the employee is vital because there is a significant cost in time and money associated with recruitment and training of new people. From the employee's perspective, staying with a single employer provides stability, security, and potentially opportunity for advancement. To facilitate the retention of employees, two-way communication between the employee and the employer, typically through his or her manager, is critical. Being able to talk with employees when they need assistance, have suggestions, or otherwise need to share information and thoughts is important in helping them feel like a valued part of the organization. Part of effectively retaining employees is to also ensure compliance with legal requirements such as OSHA safety regulations or non-discrimination laws. While it is true that employees are often reluctant to file a lawsuit against an employer given the financial and emotional costs involved, it is also in the employer's best interest to avoid such lawsuits as well. Not only are such lawsuits distractions to the routine operations of the business, but negative impacts to employee morale, the employer's reputation, and the financial wellness of the organization weigh heavily on an employer's desire to avoid litigation. When such lawsuits do occur, it is most commonly for violations of federal laws related to discrimination based upon gender, race, religion, or harassment. Beyond these federal cases, many states exceed federal protections against discrimination by recognizing additional protected classes of employees. As already mentioned, Wisconsin also includes categories such as a person's arrest record, military service, and the use or non-use of a lawful product off the employer's premises during non-working hours. The enforcement of anti-discrimination laws occurs predominantly through state fair employment practices agencies. Within Wisconsin, that agency is the Equal Rights Division of the Department of Workforce Development. Other states have equivalent agencies as well. It is not uncommon for state laws to require employees to file a complaint with a Fair Employment Practices agency before that employee can file a lawsuit against an employer. Because laws vary between states and the federal government, employees may decide to pursue a case in either the state or federal system, depending on the type of discrimination that occurred and the system, state or federal, that would be most advantageous to the employee. As a case goes through the legal process, it may become apparent that the aggrieved employee will not receive the monetary awards he or she originally anticipated and may decide to settle the case rather than risk a less than favorable resolution through the court system. Such settlements between the employee and employer are typically confidential, which presents disclosure of the facts to other parties. This could be advantageous for both the employee and the employer, especially in high-profile cases. The sad reality for a business involved in employment discrimination litigation is that even if the employer prevails in the discrimination lawsuit, it has already lost in terms of its business and community reputation, employee productivity, and money. If an agency is found liable for discriminatory conduct, however, those losses are minor compared to the punitive awards that could be levied by a court. As far as litigation is concerned, the best offense is a good defense, so to speak. Employers want to prevent litigation if they can, which typically means being proactive to create and maintain a work culture and environment that fosters diversity and prevents discrimination, harassment, and retaliation. If a complaint is filed with the employer, it is in the employer's best interest to keep an open mind while thoroughly and impartially investigating the complaint without jumping to conclusions or making prejudgments. This includes listening to the employee who filed the complaint with compassion and understanding. The employer should also be wary of taking any actions that could be deemed retaliatory against the employee, as such retaliation could result in even greater liability for the employer. To be proactive in avoiding employment litigation, the employer should document all aspects of policy training, complaint investigation, hiring and promotion practices, management development, and employee preventative training. Having and following such policies and procedures provides notice to employees, ensures consistent practices, and also helps managers within the organization by providing guidance on how to handle various employee situations. If the agency has a union, many of these provisions may be included within a collective bargaining agreement. These workplace policies and procedures should include a complaint pathway for employees to follow in the event of an identified issue, in addition to an appeals process if the complaint is not resolved to the employee's satisfaction. As previously mentioned, the rules for a unionized environment may be a little different as many states have laws that pertain specifically to the benefits and protections available to unionized employees. Rather than an employee handbook, a collective bargaining agreement may establish the process to be followed in the event of a labor dispute. In maintaining a safe, professional, and harassment-free workplace, it is important for all employees to participate in mandatory training related to the employer's anti-discrimination and other policies. It should be made clear that it is everyone's responsibility to treat others with dignity, fairness, and respect. In addition to anti-discrimination based upon common protected classes, many organizations are now also prohibiting bullying and conduct that may contribute to or be a precursor of workplace violence. Given the use of a formal investigation process, if it turns out that the employee's case is substantiated, the employer must take appropriate and timely action to resolve the situation, which typically involves some type of censure against the wrongdoer. Remember as well that retaliation against the employee who filed a complaint is illegal, regardless of whether the complaint proves to be warranted. At this point within the chapter, the textbook author shifts gears a little bit and starts talking about critical incident stress management services. Within the auspices of the employment relationship that exists between an EMS agency and its employees, it is important to recognize the emotional toll a career in EMS can take on a provider. From a retention standpoint, it is critical to maintain a safe and healthy work environment, which must also include psychological health for EMS providers. In general, the majority of people are able to balance the stressors of everyday life without too much of a problem. Within EMS, however, those stressors are somewhat different from those experienced by the general public. EMS providers routinely see people on what may very well be the worst day of their lives. EMS providers see the battered, bruised, abused, broken, and sick. From victims of crime to horrific injuries, EMS providers must maintain a calm demeanor at all times while routinely solving problems they did not create with limited information and little time. This creates stress for the provider that is often not visible to others, and even the provider may not realize the impacts or effects of such ongoing chronic exposure to such high-stakes situations. Not all stress is bad, mind you. There is positive stress called eustress that is healthy. This type of stress spurs action and assists in focus. When the event is past, the person exposed to such stress typically has a feeling of fulfillment afterward. Things may not have always been easy, but the person was able to take that experience and produce a positive outcome. Distress, on the other hand, is an adverse state where a person is unable to adapt to stressors. This can occur when the individual is overwhelmed, the situation is not resolved positively or to the individual's satisfaction, or closure cannot be obtained by the provider. Critical incident stress occurs when emergency services personnel are involved in an incident that causes unusually strong emotional reactions within the provider that have the potential to interfere with the individual's ability to function, either at the scene or later. Negative stress reactions can manifest themselves in inappropriate social interactions, such as aggression, passivity, or withdrawal. Unfortunately, one of the tragic outcomes of unrecognized and untreated stress can be suicide. While statistics on EMS provider suicides are hard to find, a 2015 Australian study by the Victorian Coroner's Prevention Unit noted an average annual suicide rate of 35.6 per 100,000 workers for paramedics. By comparison, the suicide rate for firefighters and police officers was 10.5 and 10 respectively. Line of duty deaths, especially suicides, can have a serious impact on an EMS organization. Mental health issues are important to address for your employees to maintain a healthy workplace. While originally recognized in military personnel, mental health experts now agree that emergency service providers are at risk for suffering from post-traumatic stress syndrome or disorder given routine exposure to stressful situations and human tragedies over the course of a career. Individuals suffering from post-traumatic stress can experience intrusive memories, situational avoidance, numbing in an emotional sense, increased anxiety, or emotional arousal. Flashbacks may occur during the day while awake or while asleep. An EMS provider suffering from PTSD may visibly isolate him or herself from groups or friends, exhibit a loss of hope in the future, have concentration problems, experience difficulty in performing tasks, have trouble concentrating, or suffer through relationship issues. PTSD becomes a significant issue for an employer if it results in an employee self-medicating with drugs and/or alcohol. Additional problems associated with PTSD can include short tempers, sleep disorders, difficulty in following commands, or visual disturbances, all of which significantly impacts the effectiveness of the EMS provider. While it is true that some of these symptoms may be normal after a critical event as the provider copes with what he or she just saw, it is not normal for these symptoms to continue or worsen over time. There are instances where a provider suffers from an acute stress disorder, but the serious symptoms dissipate after a while. If the symptoms last more than a few weeks and become a problem, the provider may be suffering from PTSD. The tricky thing with PTSD, PTSS, and other mental health issues is that it may take weeks or months for symptoms to develop and manifest themselves. Sometimes the onset is gradual, making it even more difficult to identify. From a legal standpoint, the body of law governing mental health issues is complicated, especially when the employment relationship is a factor in the discussion. Laws like the Americans with Disabilities Act, the Mental Health Parity and Addiction Equity Act, and the Patient Protection and Affordable Care Act all come into play, along with other laws impacting workplace safety and health, such as OSHA and workers' compensation laws. Besides meeting the requirement of the law, however, many would allege that providing not only for the physical health and well-being of employees, but also their mental health and well-being is the moral and ethical thing to do. In what is becoming a more common practice, many protective service agencies have a chaplain available to speak with their emergency providers. Some chaplains are ordained within a specific religion, while others are more general practitioners, if you will. Many chaplains provide their counseling services for free or a nominal fee, which can be beneficial, especially for smaller services. One thing to consider, however, is that individuals within the workforce may have different faiths and spiritual beliefs. If a chaplain is utilized by the service, it is important to recognize that some employees may need spiritual assistance from someone intimately familiar with their faith and beliefs. Critical incident stress management is a tool utilized by many protective services agencies to assist providers in coping with the emotional effects of a critical incident. Critical incident stress management interventions can begin in the pre-crisis phase through the acute crisis phase into the post-crisis phase. Critical incident stress management interventions may be applied to individuals, small functional groups, large groups, families, organizations, or even communities given a significant incident. A newer resource for cumulative or critical incident stress relief is psychological first aid. This approach is designed to assist people in the immediate aftermath of disaster or terrorism to reduce initial distress and to foster both short and long-term adaptive functioning. Psychological first aid is based on an understanding that disaster survivors and others affected by such events will experience a broad range of early physical, psychological, behavioral, and spiritual reactions. Some of these reactions will cause enough distress to interfere with adaptive coping. PFA assesses needs and concerns, provides non-intrusive practical care and support, addresses basic survival needs, comforts and calms, helps people connect to information, services, and social support, and protects from further harm. Many employers also have formal employee assistance programs in place where an external provider is available at any time to assist an employee or members of the employee's immediate family through stress and other times of difficulty. Understanding and providing critical incident stress management services is vital for EMS agencies to not only comply with legal requirements, but to also ensure the psychological and emotional health and well-being of its employees. More information pertaining to EMS provider health and safety, including psychological and emotional well-being, is available within the EMS Safety and Risk Management course offered as a part of WCTC's EMS Leadership and Management program. If you have not already completed that course, it is definitely recommended as a necessary component to avoid employee litigation, workers' compensation claims, workplace violence, and other issues related to a lack of emotional and psychological support for EMS agency employees. So, looking back at our initial example at the start of this chapter, what would you do with the EMS employment candidate missing fingers? First and foremost, your hiring process should ensure all candidates can perform the essential functions of the job. If those functions are not defined, that is something you will want to address sooner rather than later. If they are available, some type of physical abilities evaluation should be performed consistently across all applicants to ensure fairness and equity in the process. A physical examination should be conducted by a physician to determine the candidate's level of fitness and health. Chapter 6 of NFPA 1582, the Standard on Comprehensive Occupational Medical Programs for Fire Departments, is a consensus standard that could be adapted for use by EMS agencies, whether fire-based or not. Ultimately, someone within the EMS agency must be responsible for ensuring the testing process for hiring new candidates is fair, unbiased, and valid. In the context of the scenario, it is important to ensure that any written or physical ability evaluation is job-specific and verifiable. Academic or physical exercises that have no relationship to the job of an EMS provider are routinely rejected by the courts due to disparate impact issues that commonly arise. To summarize this chapter, the hiring process can consist of numerous stages, each needing to be thorough, consistent, and without bias that could lead to discrimination, whether intentional or not. This means having a thorough understanding of equal employment rights, discrimination, affirmative action, and other laws related to the prevention of discrimination. As an EMS manager, it is important to not only ensure fair, consistent, and valid hiring processes are in place, but the manager must also ensure the agency has enough employees to maintain minimum staffing requirements for the daily operations of the service. In the event of an employee complaint, it is imperative for the manager to respond appropriately to those complaints with a fair, unbiased, and thorough investigation. Remember that good, effective management attracts quality personnel, ensures a positive working environment, and fosters an environment in which discrimination complaints are less likely to occur. A business or related entity is only as good as the people who work for it. This applies from the president or CEO all the way down the organizational chart to entry-level personnel. Hiring good people is one of the most critical functions an EMS leader and manager can perform. Maintaining fair and consistent hiring practices is a vital component in ensuring the success of your EMS agency.